Welcome to Just Liberty, where justice and liberty meet. I'm Alan Reinach, president of the Church State Council, and I'm here with my co host, Bettina Krause, editor of Liberty Magazine. And together, we're attempting to take back liberty from the political extremes. And talk about political extremes. Our story today is a doozy. Bettina,
Absolutely.
would you go ahead and introduce our guest?
We're delighted to welcome to the show William Haun, who is Senior Counsel at the Becket Fund for Religious Liberty. And this is an amazing law firm because it advocates on behalf of not just one particular denomination or one religious group, but of all Americans, regardless of what they believe. And it advocates for First Amendment freedoms of religion. We are just delighted that you have made the time to be on the show today, Will.
No, thank you. It's my pleasure to be here.
So the case that we're going to talk about today, it caught my eye because so often when we talk about conflicts between parental beliefs and school curricula, the solution seems very difficult. But it seemed in this instance that the solution was pretty obvious. So take us back to the beginning of this case. How did it end up as this lawsuit?
Sure. You're right that there is a kind of obvious solution here. Let me try to introduce it this way. In nearly all of the country, 47 out of 50 states, it is well established that parents, precisely because they are the first teachers of their children and the family is the first society, that when it comes to complex and sensitive issues around gender and sexuality, that schools have to tell parents when they're going to instruct children on those kinds of sensitive issues and provide the parents an opportunity to opt their children out of any instruction that might infringe on their religious upbringing. As I said, this is standard practice in 47 out of 50 states. And the three that don't speak to that directly simply don't speak to the issue at all. So it's not even like they go the other way. Montgomery County, Maryland was a part of that national consensus for a long while, and not only on the issues of gender and sexuality, but its public schools allowed for religious based opt outs to every kind of instruction in its curriculum: Halloween parties, Valentine's Day parties, music class. You could receive alternative reading assignments if something were to violate your religious upbringing. And even as to the books that are at issue here, starting last year or now in 2023, Montgomery County Public Schools set forth a series of books, which we call the Pride Storybooks, into its elementary school curriculum, starting at pre-K, which is meant to introduce children to gender transitions, celebrate playground same-sex romances, walk a pre-K student through a pride parade, help them identify lip rings and underwear and sex work and a sex worker, all starting at 4 years old. And then also starting in third grade, starting to talk to your parents about how to have a gender transition discussion. And along with the books also came discussion guidance that the board set forth to teachers to encourage teachers how to have certain conversations. So, for example, if a child were to raise his hand and say, after reading one of the books, I thought if you're born a boy, you're a boy, and if you're born a girl, you're a girl, the teacher is encouraged to say, that's hurtful, that's offensive, but no one actually really knows who you are. Doctors are just making a guess when you're born. Only you really know inside. For almost the first year that these books were in the Montgomery County Public School curriculum, consistent with that national consensus and what Montgomery County does on every other aspect of its curriculum, it told parents in advance when these books were going to be read, and it provided an opportunity for parents to opt their children out of those discussions and the reading. But then, for reasons that were never publicly explained, in March of 2023, the board simply announced that going forward in the new school year, so the school year we're currently in, there would be no more advance notice to parents when these books were being read. In fact, parents would never be allowed to know, even after the fact, if the books were read. And there would obviously be no more ability to opt your children out of reading or discussing them. A number of our parents instead were told that if you would like to read the book and you can pre teach it to your child, you're welcome to do that. Totally glossing over the fact that for many of these families, introducing this kind of content to a 4-year-old or a 5-year-old violates their religious beliefs and their authority as parents. So, a variety of religiously diverse coalition sued Montgomery County Public Schools not to take the books out of the curriculum, not to ask the county to adopt another curriculum of books, but simply to restore their ability to know what their children are learning and to opt their children out of instruction that violates their religious beliefs.
So, Will, the first question I have is both nationally and locally, is the opt out privilege only based on religion? Because with this curriculum, I think that there are a lot of parents who don't necessarily profess a particular religious basis for objecting who would find it objectionable.
Right. So there are definitely the consensus I mentioned, the national consensus, simply respects the authority of parents to direct their children's upbringing. And certainly when you're talking about an issue as complex and sensitive as gender identity and sexuality, this goes to a child's self understanding. Of course, the parents have a preeminent role in those kinds of areas. The law is most, I would say, deeply established when it comes to religious upbringing. And certainly this touches on that directly. But yes, we have parents who have made the point precisely that just as a matter of anthropology, I mean, this is not how they are going to be directing their children's understanding of the human person.
So just to clarify, these parents are not asking for these books to be removed. Is that correct?
That's right.
Right.
That's absolutely right. I mean, the point of this lawsuit is to vindicate, as I said, and to restore that right to notice and opt out that the county itself already acknowledged for the parents until March of 2023. Um, Now, the democratic process where you run for school board and have debates about what should be in the curriculum, I mean, that's a separate question. But in terms of what the courts do and what this lawsuit is about, this is about restoring that right for parents to know what their children are learning and to opt their children out of religiously violative instruction.
It strikes me that we think too often of religious liberty as kind of a very sort of national or global type of issue. But really, when it comes down to it, so often these challenges are, you know, struggled through at a very local level. Here you've got a county in a state, a county school board and a county policy, and the battle for religious freedom here within the county.
Yeah, well, it's a great point. Montgomery County is the most religiously diverse county in the United States of America. And
Really?
it has around, yes, and it has around 160,000 students in all of its public schools. I actually lived in the county for 7 years. It's huge. And so there is an opportunity here for the county to set a national example, a positive one. It's a county that has many immigrants. It's a county that has very broad religious accommodations, like I mentioned, throughout its school curriculum and accommodations that even applied to these books until March of 2023. So it's really unfortunate that the national example the county's setting is this one, when it could be setting one that reflects, as the Supreme or as Justice Alito put it, the spirit of practical accommodation that is a response to just the fact of pluralism in the United States.
And that really goes to my next question, which is what are the reasons that are being given for this sort of digging the heels in and refusing to restore the opt-out provision? Is there a stated reason why this clearly easy solution is not being embraced?
Well, like I said, when the opt outs were withdrawn, there was no public explanation as to why. But what the county has said in court is they've acknowledged they've said that there would be administrative difficulties with the opt out. Essentially, the theory is we can't allow opt outs because too many people would want to opt out. Now, setting aside a lack of self awareness in a policy like that, There's just simply no evidence behind that. Like I said, there were opt outs to these books for the better part of a year, and there wasn't any kind of argument like that. And moreover, as I mentioned, the national consensus about opting out of sexuality instruction in general, Maryland law requires that if you want to opt out of these discussions and say the sex ed portion of the health class, the public schools have to honor that. They must do it. And so we're in this kind of awkward situation now where if a senior or junior in high school wants to opt out of a discussion about gender identity in sex ed, Maryland law requires the Montgomery County honor that opt ed. But if a 4 year old or a 5 year old is going to have a discussion about gender identity in English language arts, they can't opt out. And this does not make any sense.
So, Will, I gather that the case is before, well, you've asked for the case to be heard by the Supreme Court. The Supreme Court has not decided. That suggests to me that the lower courts have ruled in favor of Montgomery County and have said, oh, no, this doesn't really violate the religious freedom of parents. We're not telling the parents how to practice their religion or what to teach their children. So, talk to us a little bit about what the lower courts did and where they got religious freedom wrong here.
Sure. Yeah, so you are right that both lower courts, although with a dissent in the Fourth Circuit, sided with the county. And the basic logic of the court's decisions is that in order for the parents' religious exercise to be burdened, their children need to actually not only have had the books be read to them, but also be forced by their teachers to agree with them. This is rather unusual reasoning because what it's basically waiting for is for a 4 year old or a 5 year old to be forced to take a position on rather complex and sensitive issues like gender identity and sexuality and then voice an opinion on it. Not sure people who've ever interacted with 4 or 5 year olds can recall discussions occurring like that. But even setting aside the common sense point, legally it's problematic because the entire point of a Bill of Rights and the entire point of the kind of relief we've asked for here, which is called a preliminary injunction, which is you stop potentially unlawful conduct before the harm happens so the court can actually figure out who's right and who's wrong without a change in the underlying circumstances. The whole logic behind that is you don't have to sit around and wait until the toothpaste comes out of the tube before a court does something. But as far as Montgomery County is concerned, we do have to sit around and wait until the children's innocence is destroyed and the parents' religious liberty is violated. And then we'll decide whether or not they even had a right to vindicate in the first place. But at that point, the damage is done. So you don't sit around and wait. That's not how fundamental rights work. That's not how the courts work.
Well, but beyond that, I mean, so your response has to do with like the preliminary injunction process, but the county is also arguing fundamentally there's no violation of religious freedom here to teach the kids something that the parents, say violates their religious beliefs. Can you speak to that issue and why that really is a violation of religious freedom?
Right. Their view is that they can expose your child once they get dropped off at public school, or he or she gets dropped off at public school, to virtually anything. As opposing counsel told the district court, once professional educators select a curriculum, there's no free exercise claim. Uh, that kind of surrendering of your rights to the government is artificial. It's not actually what goes on here. Parents, public schools do have authority, but they have authority that's delegated from the parents. It's called authority in lieu of the parents. And that only makes sense when you are actually operating in lieu of the parents. But the entire premise of Montgomery County's policy here is to exclude the parents from ever even knowing about what their children are learning. So, how can you say that you're operating in lieu of the parents when you won't even tell them? You won't even give them a straight answer as to whether these books are being read. Parental exclusion is not operating in lieu of the parents.
So, Will, what happens as a practical matter if the Supreme Court denies cert, says it will not hear this case. What options do the parents have at that point?
Yeah, if that does happen, we'll be sent back down to the trial court where the county has asked the district court to dismiss the case completely. We have opposed that because there are paths forward that the Court of Appeals left for us to try to show the coercion that is happening in the classroom with the books. Um, so we articulated what those paths might be, and then it would be up to the district judge to make that call, and potentially we could have appeals beyond that point.
I'm still stuck on the idea that you give up your First Amendment rights when your kid goes to school. And I'm thinking about back in the Vietnam War era, there was a case, I think it was called Tinker, about wearing protest armbands, black armbands, right? Like protesting against the war. And the Supreme Court said, yeah, you have a right to do that. I mean, we've acknowledged that students have constitutional rights in school for decades now, right?
Well, that's right. Students certainly do, and the argument here is that somehow that doesn't extend to their parents, even though all of the authority that the schools possess is dependent upon a delegation from the parents. And as Justice Alito said in a controlling opinion for the Supreme Court, Morse versus Frederick, it is a dangerous fiction to presume that parents simply outsource to the government, which is that's what we're talking about with public schools. We're talking about just an agent of the state their authority to give their own children any political, religious, ideological message that they want to hear. That is simply not part of the bargain with public schools. Public schools are supposed to partner with the parents in the education of their children and not impose upon them the ideology of the day.
It, the whole issue of education has become such a flashpoint for many of these issues, not just in Montgomery County, Maryland, but across the nation. As someone who has engaged with this case, what would you say would be best practices for parents who find themselves in a situation where they have a religious objection to something that is being taught to their elementary school child?
Yeah. I am blown away, truthfully, by the courage of our clients. Uh, these are clients who sacrifice greatly for their children's education, that want to see their public schools, which they pay taxes to support, to be the best that they can. And so they are active in their public school meetings. They are active in emailing and corresponding with their teachers and school officials, and I think that's really the first best line of defense is just open communication. Because honestly, one of the things that's just so unfortunate about the record here is that the teachers of the students, in many cases, really wanted to accommodate the parents and really tried to work with the parents to come up with reasonable arrangements, even with the board policy. There's a memo in this case that the principals, the elementary school principals of Montgomery County Public Schools, put together and said, look, this curriculum is going to be dismissive of children's religious beliefs. It's going to shame children who disagree, and it's going to cut out the parents from parts of their education. You really shouldn't do this. That's what the principals, like the principals union, put that together and told the board that. Didn't matter. So, that's really, I think, at the ground level, at the human level, there is between parent and teacher, there's still plenty of room for kind of constructive partnership. And hopefully that can be the basis for a better outcome.
So, your last comment will raises for me interesting kind of legal explorations here because we talk about parental rights, we talk about free exercise, the rights of parents, in terms of their own religion and directing the religion of the kids. But there's also the Establishment Clause that I think at a minimum says that the state and its institutions can't act in a way that is overtly hostile to people's religion. And what these principles are acknowledging is that this policy is overtly hostile to the religious values and beliefs of many families in the community. I'm going to be in court this afternoon on a case arguing the very same issue in a very different context about, the Establishment Clause does not permit hostility to religious beliefs. Is that something that has been part of this case at all, or at least do you agree that there is that offense, that the notion of separation of church and state means that the government can't be directly hostile to our beliefs?
Certainly, if the school board is trying to do things to exclude religious perspectives about the human person and sexuality from discussion, and the principal's memo says this is going to be dismissive of religious beliefs, yes, that does indicate hostility, and that is inconsistent with our traditions. I mean, and there are Establishment Clause cases that have made similar points. And we've made the point here with regard to the hostility from a free exercise standpoint. When this curriculum was being put together, there were really unfortunate statements made by county officials. One school board member accused parents of, or a child of parroting the dogma of her parents. Another a county official lumped in these parents with white supremacists and xenophobes simply because they wanted to direct their children's religious upbringing. The same school board member I mentioned said that if you want to opt your children out of the kindergarten reading of this book about pride parades, that's just telling your child, here's another reason to hate a person, as if there just could not be a serious reason why these parents would want to direct their own children's religious upbringing, particularly when we're talking about 4-year-olds, 5-year-olds, highly impressionable young children who instinctively trust authority figures. I mean, that kind of commentary is really unfortunate.
There's a massive irony here because this curriculum is clearly designed to promote inclusivity and to help students be kinder to others. And yet it is fostering the kind of inclusivity which is actually hostile to many members of that community. And it speaks to me of a larger issue that we face with religious liberty these days, which is the accusation that it is merely a cover for religious bigotry. And it seems to me that we, as people, the magazine I edit, Liberty Magazine, the cases that you deal with, one of our major goals needs to be to help people understand that this is not mere religious bigotry.
Well, I think an important way to illuminate that is think about what the stakes are in these religious freedom cases. Ultimately, what we're talking about is does the civil government, does the state, does that get to be the only thing in all of society that gets to tell you here morally is what the right answer to these ultimate difficult questions are? Is that really the only entity in society that gets to say anything about that? And you're free, maybe in the privacy of your own home, definitely not when the children are around, though, to whisper quietly a different point of view. Are we going to treat religion like smoking, as if it's just something that is just a social outcast that you definitely can't do in public and probably not when the children are around? Like, is that what we think of any other entity in society that might say, actually, here's what I think about this ultimate question? And when we're talking about the authority of parents, I mean, that's really kind of amazing because the parents are the first society. They're the first teachers. The schools wouldn't exist without them.
Well, the problem as I see it, Will, is that for those who are purely secular, uh, religion really is just, you know, either a harmless myth or very, very dangerous, um, you know, cause of so many wars and violence throughout human history that there's no reason to respect religious freedom. But obviously, for those of us who have an experience of faith, uh, we resonate with the things that James Madison wrote about how religion is wholly exempt from cognizance by the government because it's a duty that we owe to our creator, which precedes any obligations we have to civil society.
Well, this is the thing, right? And I think even Sure. I mean, Montgomery County, Maryland is not going to be confused with Texas anytime soon. But even there, like I said, this is the most religiously diverse county in the nation, and out of respect for their neighbor, they had some of the most robust religious accommodation policies that you could ask for in a public school. So I don't think that you necessarily have to take a particular vision of religion and in order to be committed to religious freedom. I think the county is an evidence of that to some degree. But to your point, this gets to a very fundamental question, which is ultimately, if our rights don't come from a higher power than the state, then where do they come from? If they just come from the state, why can't the state take them away? And if now you may be okay with the fact that they're taking mine away today because you don't like how I'm going to exercise my rights, but what happens when turnabout becomes fair play? I've yet to hear a good answer to that question.
No, absolutely. I mean, democracy is not a good way to protect fundamental human rights. The will of the
This is
majority.
why we have a Bill of Rights, right? I mean, this is why we don't get to vote away the freedom of speech with 5149. It takes much more than that.
Well, and this is why your organization and the Seventh day Adventist Advocacy for Religious Freedom acknowledges and protects the rights of people of all faiths. And we don't just advocate for our own rights, because, yeah, we recognize that if you lose your rights, then my rights come next.
Yeah, I mean, the Becket Fund takes its bearings from the Second Vatican Council's Declaration on Religious Freedom, Dignitatis Humanae, and that document speaks in terms of the civil power, the civil government, saying, look, when it comes to the ability to direct people's religious duties, the civil power simply has no authority in that area. It simply does not. That is an authority that resides in a higher sphere. And in our kind of society, a society that has always been a pluralistic society, and a society that only has in the civil sphere just that temporal power, there's just no authority over religion. So that has to be left to the higher sphere.
And that is a good note on which to end our conversation. I have so enjoyed this conversation, and we will be thinking of the progress of the case that you're involved with, Mahmood versus Taylor. And we will be thinking of you also as you engage in many, many important religious liberty cases in the coming months and years. So thank you so much, Will, for being with us today.
No, thank you. It's my pleasure.
Bettina, after listening to this story, it's no wonder that there is such a backlash on the right against the excesses on the left. I mean, I remember back when I was still in New York, back in the early 90s, there was a big stink over a book called Heather Has Two Mommies that was being introduced in kindergarten. We're way beyond that now with what's happening in Montgomery County, Maryland.
Absolutely. When I read the facts of this case, Alan, I mean, I thought, is this a joke? This has to be a joke in terms of the utter refusal of the school officials to compromise on their agenda. And clearly, it is an ideological agenda in this case. Otherwise, a common sense compromise would be welcomed by all. But clearly, this is an agenda that's been driven, I'm guessing, by two or three individuals on that school board who just simply will not give way, and that is unfortunate. It's unfortunate not just for those kids and for the parents involved, but also for our national discourse about these really difficult issues.
Well, the hubris, it strikes me, for people to say, I have a right to impose my ideology on other people's kids, and to fight for that level of intolerance is really quite astonishing.
It's ironic because people often accuse religious folk of being zealous and refusing to compromise. Well, that level of zeal is also evident on the left. And it is a human failing to think that you are right, I am right, and my point of view should prevail, come what may. It's a good lesson to all of us to take other people's objections and beliefs seriously and to really engage with them with a little bit of humility.
It's funny you use the term humility because that's just what was going through my mind. The most important lesson I learned in law school from a very successful, accomplished professor was humility, the willingness to turn over an argument and look at it from many different points of view and not assume that your view of the facts and of the law is correct, and that's a really important quality to be a good lawyer. Well, it's a good quality, for life, I think,
I was
and the
doing
Bible certainly agrees.
I was doing an interview, Alan, just the other day with Professor Anazu, John Anazu from Washington University in St. Louis. And he's written a book on how to disagree, or learning to disagree, I think the name is. And he made exactly the point that you just made, that when he teaches his law students, he tells them, you can't just go into the courtroom and say, the other side has a stupid argument and they deserve to lose. You actually have to go and you have to closely examine the other side's argument and you have to take it seriously and you have to engage with it. And then you have to go into court and say, the other side has a good argument, but mine's better. Here's why. And I think that's a great lesson for us, I think.
Well, and that's what I'm trying to do with, a case that, I'm gonna be in court on this very afternoon, is
Oh,
to
really?
engage with their argument, which and my perception was they were not engaging with mine.
Huh. Huh. Well, good luck with that, Alan. Hope it goes well. And thank you for joining us today. And until next time, I'm Bettina Krause, together with Alan Reinecke. And remember, eternal vigilance is the price of liberty.